everybody. Hey, Spitting Fire. Hey, Ruby. Hey, Sierra. Hey, Tori. I realized I had some footage still left over from yesterday, and I said I was gonna play it for you guys. How's everybody doing? I'm going to go ahead and play these footage for you. This is like from the end of the day yesterday. This is from Young Thug's trial. Well, I don't know if you could still call it a trial. It's something. I don't know if it's a trial, but it's something. But anyway, I'm going to go ahead and share this with you guys. And we could probably talk through it. All right, let's go. Hey, sis. Did you enjoy your birthday? Can y'all hear it?
And Ms. Von Kelch and her team will then identify those people that we need to examine, and we should be able to have a full day with the usual customary breaks around lunch and for comfort. So, and then we can kind of talk about when we are going to examine over the remainder of the weeks of the 6th and the 13th. So that's kind of the short and the medium.
Okay, did he say, what is he's talking about the schedule, right? Hold on a second. I need to back it up a little bit. Because I think he's talking about the schedule. What he's going to do. Hold on.
For the remainder of the weeks of the 6th and the 13th. So that's kind of the short and the medium game plan. Okay.
Okay, I missed some parts of it. Hold on. Hold on, I gotta go from the beginning. Hold on.
To address jurors 7:15 through 8:15 will be here tomorrow to fill out their questionnaires and identify themselves for hardship. And Ms. Von Kelch and her team will then identify those people that we need to examine, and we should be able to have a full day with the usual customary breaks around lunch and for comfort. So, and then we can kind of talk about when we are going to examine over the remainder of the weeks of the 6th and the 13th. So that's kind of the short and the medium game plan. Okay. Mr. Randolph, is the next person that we have 622, sir?
Yes, Your Honor.
Okay, thank you, sir.
Okay. Because he's not allowing us to see the jurors. What we're going to do, the next one that I have here is I'm going to turn the volume down because the judge doesn't want us to play the jurors' voices, okay? So I'm going to turn the volume down on the next clip that I have. But this clip is basically I want to show you guys the defendants because get a chance to see them because the family looks at this channel, and this is the only opportunity to have a chance to look at their loved ones. So I am going to play the next clip only the with the volume off, so they could get a chance to hear their loved ones. Okay, so let me just go ahead and take care of that. Because this one here is going to give them a chance to see their loved ones. Okay. All right. Then remember the volume is going to be down so nobody says, "Oh, I can't hear nothing. I can't hear nothing." I'm turning the volume down. Okay. All right. Here we go, guys. So at this time here is when the jurors coming up, the potential jurors coming up to do their hardship. So they're going to be listening to him. So what the camera guy did, because I had sent him a message requesting that he send me some clips, and so he was showing some of the defendants for me. Okay. Did some of you guys get a chance to see me on IQ channel? Maybe I can get little Rod Dad on here because he works through the night. Maybe I can get him on here. Y'all want to hear him today? He had told me to give him the link when I go on. So no, I'll go over there and check it out. Yeah, he is very funny. He is very, very, very funny. The guy seems very like intensive today. You see, all of them have their laptop and headphones on. I think they're going through the Discovery. What is whose channel? No, no, no. I was gonna bring them here on my channel. On my channel. Oh, you missed it today, Rand. The judge denied the mistrial motion, and he denied the state's motion as well. But he did say that he's going to do an investigation. He said he was going to do a investigation on how it was leaked and things like that. So what I could do, I'm going to play it for you. I could play it for you. That was earlier. Okay, I'll stop this one and I'll play it for you since it's your birthday. Well, it's no longer your birthday now, but I'll be nice because we can hear the voice on that one. We can hear the voice on that one. Let me take that down. Let's play it for you. Hold on. The video. Okay, is this? Okay, is there a video of this person that got leaked? You mean the the video of the guy itself? That video? You want that video? I didn't want to play that one because the judge was talking about how it was seen 30 million times on social media. He talked about that. Yeah, he talked about how it was shown that many times on social media. Yep. Let me go play. I think this is the one right here. If not, I gotta go downstairs and get it if it's not the one here. Hold on. No, if you don't want to. No, I don't mind playing it. I don't mind playing it. No, I thought I didn't want to play the video itself. Oh, you want to hear it? Yeah, okay. That's what I want to play. I'm going to play that one. But the one that with the actual guy in the interrogation room, I don't want to play that one. That's the one he says has had over 30 million views. Hold on, let's play this one.
Okay, so 616 has a travel issue.
Yes,
And
Your
what was
Honor.
the other one, madam?
623.
That's a language barrier?
Yes, Your Honor.
And is that a Spanish speaker?
Yes, Your Honor.
All right, do we have Mr. Lara with us?
Solares is right there.
Okay, we can take him up in just a minute. Or, yes, thank you, Mr. Lara.
And then juror 635 has an affidavit.
635.
Where can you see the snitching video? You can see that on academic. Okay, let me see. Let me get that video for you.
The only juror who did not report is juror 680. And this juror had verifiable proof that she was going to be in the hospital from Monday
That was
through
Little
Friday
Woody?
for an
YSL Little Woody.
EEG test. So we've arranged for her to come in and complete her questionnaire when she's released.
Okay, so juror 680.
Yes, Your Honor.
Okay. Madam, anybody else? I did,
He is supposed to be a YSL.
can you talk with the group here? This is not probably part of our group, but just to put this on our radar, since I did talk about juror 798.
Yes, Your Honor.
Councils, remember, 798 was appeared on Friday, and I was going to issue a rule nisi for a contempt proceeding because that juror left. 798. That was from this past Friday. It has come to the court's attention that juror 798 appeared at 8:15 in the morning for jury duty pursuant to their summons. This juror had a 16-year-old daughter that was scheduled that had oral surgery that morning to remove her wisdom teeth, and his wife accompanied the 16-year-old to the surgery. There were some complications. The wife called the husband, and at about 9:25 he left. So that is to assist his wife and the daughter, who was still sedated at that point in time. So does that kind of summarize
Yes,
juror 798 situation? Councils, with your permission, I can certainly bring juror 798 back in for examination. I believe that given this particular scenario, that could probably affect anybody who's got a child. I would like to, with your concurrence, defer 798 service.
It's fine by Mr. Williams. No objection.
And Your Honor, we can even defer him to the 17th of March if you want to examine him at another time.
Let's just do that. Okay? All right.
Okay, thank you, Your Honor. Those are all my announcements.
Jesus.
Oh, So we were saying
hold on.
that I would defer this juror to March 17th. That is when the next group of jurors comes in on this case.
Yeah, so that juror will just be repurposed for the 300 folks that come in on that date to hear the video and go through the same procedure we're going into, because he would have missed our video, and that would just put him back in square one. Does anybody have any objection or comment about that?
He'll keep the same number, 798.
No, he'll probably have another one.
Oh, okay.
It'll probably be he would probably just show up at that in that particular order. We'll just have him report back for that date to go through the process.
Okay, thank you, Judge.
Okay. Anything else, Ms. Fonkhouse?
No, Your Honor. Thank you.
All right. We'll talk about probably once we kind of get started. What did you tell these particular individuals what date they who were beyond the 30 that you chose for today, what date they would need to come in?
I did not give them a date certain, Your Honor. I
Okay.
did not know how today would play out, but they have the phone number, and we referred them to that number to
Okay.
call every night. So
Wonderful.
they will know when to return.
Okay. Thank you. Thank you, madam.
Yes, Your Honor.
Okay. All right, councils, can we just recess in place? I believe we have a request for a restroom pause. So I'm just going to recess in place for that to occur.
Okay, just 1 second, y'all. Let me go get the other one so y'all can see. I'm gonna play it for you, Rand. Hold on. All right, I'm gonna play it for you, Randa. Hey. Oh no, it happened yesterday, Manuel. It happened yesterday. I was playing it for her. Let me go ahead and finish this one off while I go get the other one, and then I'll play that video for you, Randa. Oh, the YSL one. I'm gonna send you the link to it. I'll put the link in the chat so you guys can go look at it. Okay, here's the link, Rand. You can watch it later on. Here's the link for that video. That's for the video of the leak for the interrogation. Okay, let me finish playing this one here.
All right, Deputy Talton, do we have everybody present, sir? Yes. Okay,
Yes, Your Honor.
Mr. Laura, can I go ahead and get you to facilitate the examination of juror 623, please?
Yes, Your Honor.
Mr. Laura, where are you, sir? Mr. Laura, can I get you to step around front so I can go ahead and get you to help us out with juror 623, I believe is a Spanish speaker. Can I get you to raise your right hand for me? Let's just go ahead and swear you in. At this point in time, raise your right hand. Do you solemnly swear or affirm that you shall well and truly interpret those responses from English to Spanish and Spanish to English to the best of your knowledge and belief?
I do, Judge.
Okay. And you're a state certified interpreter, is that correct?
I am, Judge.
All right, sir. You can put your hand down. This is juror 623. Juror 623, can you have him come up to the podium, please, Mr. Laura? Or the witness stand, I should say.
Okay, y'all, I'm gonna take this one out. And then I'll put the other one in for y'all. You think it was leaked by the police? Interesting. Let's see. Hold on a second, guys. Just bear with me a second. I'm going to bring up the hearing. Okay, let's go ahead and present that. Will he reread the mistrial after the investigation? No. He denied the mistrial. He denied it. All right, here we go, y'all.
The state's motion for an order reinforcing the court's directive prohibiting dissemination of discovery pursuant to OCGA 17-16-4 Delta. And then the response to the state's motion for an order reinforcing the court's directive pursuant to that same code section, OCGA 17-6-4D. Let me recap what is alleged. And Ms. Bernard, you can certainly augment this, but I'm just going to put for the purposes of the record just what has been filed so I can rule upon it. On or about, councils, if you all recall, on September the 9th, I signed 2022, I signed an order specifically restricting the disclosure of discovery materials pursuant to this particular statute, OCGA 17-16-4D. And in section 5 of that order, it states as follows: all parties are prohibited from sharing discovery material with any news media sources, social media, or other public forums. It also, within that order, specifically details that the defense counsel is prohibited from sharing discovery with non-members of the defense team. Defense counsel may meet with potential witnesses and show discovery information to those potential witnesses as needed, but the defense counsel must prohibit those witnesses from recording, photographing, taking notes, or receiving a copy of any discovery materials.
Thank you, Monique.
All
Appreciate
parties,
you.
Paragraph 5. are prohibited from sharing discovery material with any news media sources, social media, or other public forums. It has come to the court's attention
You can go in
through Ms.
person.
Bernard's motion and the state's motion that on or about February
Well,
17th,
y'all have until June.
some
Trial
discovery
won't
material
start till
was
about
disseminated
June.
on social media in clear violation of this order. That was apparently a witness interview of somebody that is going to be called potentially at trial. That particular video has garnered some over 30 million views on social media as of yet, and probably counting. And that would be in direct violation of this court's order. Now, you all in this courtroom are very seasoned advocates. And without I don't want to necessarily get into down in the eaches as to what or who might have disclosed this particular information, because I can't do that right now. And certainly it.
Okay, hold on, y'all. I'm going to go ahead and show y'all the video, okay? Hold on. Some people haven't seen the video yet. So I'm going to stop this and then I'm going to show y'all the video. All right, here we go.
You said my bond?
Yeah.
How y'all gonna revoke my bond?
Then the attorney on the case is gonna move to revoke your bond. So I'm gonna see you next week at your bond hearing. But I have to see, I don't wanna violate your rights, Mr. Melnick is your attorney, okay?
Yeah, I don't need my attorney right now.
Okay.
I'm talking to you.
But what I'm saying is, okay, Investigator Flores that's gonna come in here, is probably he's probably the most down to earth, coolest one you're gonna get here, okay? So, but I trust him with everything, that's the only other really one I'm gonna work with. So if you trust me, because you know I looked out how many, over the years, have made sure haven't I tried to talk some sense into you?
It's not serious.
What?
I'm not saying serious.
About serious about what? What you just said? What I'm saying, like, you know that I care about you, you know, listen to me, with your two daughters, remember I tried to get you some help? Like, it's been a long time with us, like, I've never done anything like out of character, like,
You won't even tell me what I'm here for.
this is the APD thing, so what I'm
What
saying.
you are? Are you FBI?
No, I work with I'm at the DA's office now, as an investigator in their gang unit.
You said you're investigating?
At the DA's office, at the Fulton County District Attorney's office. I'm an investigator in their gang unit. So, if you give me a minute, let me call somebody. I don't want, like I said, I gotta make sure everything's done correctly. I don't wanna, but you're saying you'll talk to us without, I don't know, I'll take you to a different floor, okay? Okay, but I don't want, if you're gonna talk, I don't want anybody to hear you, okay?
You going to jail too?
Who is that? Who's in that room?
Mine.
I don't know. Is he a felon? I don't know. I don't know him.
I
I just know Mad Bond, that's all I know. I don't know if it's like a real deal.
but it's crazy, man.
Okay, listen.
If I'm going to jail, I ain't got nothing to say.
Okay.
And I told you this today, and when you see that, you're gonna know.
But what I'm telling you is, can you give me a minute to make a phone call so we can talk about, I wanna make sure everything gets done correctly. Just
If
give
I'm
me,
going to jail, I'm not gonna say nothing. I don't want to, because I've been tortured, y'all torturing me, and y'all still torturing me. I stay away from everybody. I stay away. I haven't hurt nobody. I haven't done nothing to nobody. I haven't. I stay away from these niggas. All I do is try to go here and live my life.
okay, please give me 1 second, I'm gonna come right back, I promise.
All right.
I promise, okay?
I'm not opening my mouth. Y'all trick me last time.
Tricked you with what?
I tricked myself, you right.
Who tricked you last time? I've always been honest with you.
Okay.
When they came and got you at the house, that wasn't, I got it. What do you say? Did you say something?
Nope.
Yes, she was fired. For 11 years, Randa. 11. 11 years. They said he was a informant for 11 years. But she did get fired allegedly, so I don't know facts on that. I don't know, Rand. I don't know. But the other his girlfriend was a CO and she got fired too because they said she was interfering with a case or something like that. And she's in jail. This was in October 2021, Sharon. Sharon, what you still doing up? And he's in jail, Rand, but he's not part of this case. Yeah, the uh-huh. Oh, she deleted his IG? Oh, okay, that's what she did. This video is like 3 hours long, y'all. I'm not gonna play this whole video, but I put the link in the chat for those who want to see the whole video. But it's 3 freaking hours. Yes, he's in jail. Yep, he's in jail. He did something else in April 2022, and he's got charged with multiple charges. I do have that information for you. Hold on a sec. Hold on. I'm definitely gonna watch it. Fast forward. Okay, let's go. Did he take a plea? No, he's not even part of this case. He's not part of it. He has his own case going on. I can show you some the charges that he has. Let me stop this for a second. Yeah, y'all can go and watch this later on because this is like 3 hours long. Okay, that's 3 freaking hours long. But let me go ahead and pull up the his charges for you guys. Hold on. Just 1 second. Okay, hold on a second. Okay, he is charged with theft by taking auto, um, aggravated assault with a deadly weapon, entering auto, aggravated assault with a deadly weapon, theft by receiving felony, possession of a vehicle with alternate VIN, possession of something sub in school. There's a 1, 2 WID charge on that one. Let's see, there's something else. Hold on a second, y'all. He has multiple charges. Hold on, let's go back. And then here is his offense. I'm going to show you guys his rap sheet here. Hold on a second. I'm going to show y'all his rap sheet. Okay, here it is right here. You guys can see this, right? His name is Kenneth Copeland is his real name. Kenneth Copeland. And he got charged with repeat offender, non-complex, and okay. So that's what he got charged with. And the case is open. And this is when it was filed on April 1st, 2022. So that was last year. Okay. All right. So who's IG? You said, what's her IG? What is this? She follows. Who is it? Who's IG? Let me see what y'all talking about. Okay. You guys, let's go back to watching the hearing. Just play a little video. Okay. Okay, I'm gonna go ahead and play. Well, you want more of that video? Okay, I'm gonna. The detective IG. Oh, okay. Okay, let's go ahead and finish playing this the judge ruling. Okay, I'm gonna start it over a little bit so we can hear it. All right, hold on. Let me put my marker back up because folks will steal my stuff. I have to put it back up. Okay, you said yes. I'm trying to figure out what you said yes for. This is the court update. This is as of today. Well, yesterday. Today is the new day already. All right, share. All right, this is what happens today in regards to that motion.
September the 9th, I signed of 2022, I signed an order specifically restricting the disclosure of discovery materials pursuant to this particular statute, OCGA 17-16-4D. And in section 5 of that order, it states as follows: all parties are prohibited from sharing discovery material with any news media sources, social media, or other public forums. It also, within that order, specifically details that the defense counsel is prohibited from sharing discovery with non-members of the defense team. Defense counsel may meet with potential witnesses and show discovery information to those potential witnesses as needed, but the defense counsel must prohibit those witnesses from recording, photographing, taking notes, or receiving a copy of any discovery materials. All parties, paragraph 5, are prohibited from sharing discovery material with any news media sources, social media, or other public forums. It has come to the court's attention through Ms. Bernard's motion and the state's motion that on or about February the 17th, some discovery material was disseminated on social media in clear violation of this order. That was apparently a witness interview of somebody that is going to be called potentially at trial. That particular video has garnered some over 30 million views on social media as of yet, and probably counting. And that would be in direct violation of this court's order. Now, you all in this courtroom are very seasoned advocates. And without I don't want to necessarily get into down in the eaches as to what or who might have disclosed this particular information, because I can't do that right now. And certainly it affects everyone's right to a fair trial under our U.S. as well as our Georgia constitutions, particularly the 5th and 6th Amendments in particular. But I want to just remind everybody about their obligations under those of you who are lawyers and who supervise paralegals and other support staff. Under Rule 1.6, which many of you probably not looked at it at 30 or more years, some of you that have been practicing that long, or varying lengths of time since you took the ethics course and passed the MPRE. That's the bedrock of our profession is confidentiality. And we're supposed to keep confidential information close and be a close hold. So many of the things that we learn from representation, we can't share with anybody. This is just a prime example of a potential disclosure in violation of 1.6. Now, I don't know who did this, but if this pertains to you, then please kind of just amend your ways and kind of just think about how you keep information safe and who you're sharing it with, because you're playing a very dangerous game with your 6-digit bar number. Because one of the things I will do as a result of this disclosure is I will go ahead and order an investigation. And I'll tell you that the computer forensics folks are really good these days at finding the source of people's disclosure. So that's later, and I'm not going to take that up now because that's not something I'm equipped to do, but I am going to order an investigation in terms of that because my orders to you all are not aspirational. They're for the purpose so that everybody gets a fair trial. So if you think you might have leaked this particular information because you could tank your buddy or tank somebody else's ability to try to have a fair trial, that would just be wrong on all levels. Like I said, I don't know. I'm not casting aspersions on anybody because I don't know who did it. But I'm just reminding you of your obligations as professional advocates to play by the rules. The rules are designed so that, especially the rules of ethics and the rules of discovery in this particular case, so that people can be protected, people can have a fair trial, people can have a lawful trial. And that's the only reason for it. And for this to have occurred and for me to have to deal with this at this point in time in the trial is just unacceptable. So I want you all to think about that. So Ms. Love, if you'll prepare a suitable order for my signature to an investigation, I will go ahead and do that. And as a result of this particular disclosure, this is the last time I'm going to have a conversation about this. If I have another conversation about the disclosure of information, then you're only going to get it from my chambers, either in the courtroom or in the jury room. I'm going to restrict it to that particular area for it to be looked at, because I can control that. So, as I said, this is not, and Ms. Bernard, thank you for bringing this to my attention. I'm sure that it would have probably come to my attention otherwise. At this point in time, Madam, however, I'm going to deny your motion for mistrial. However, I will permit you and your colleagues, as appropriate, as people come in, both sides, to ask them if they have heard about this video and if that affects their ability to be fair and impartial to your particular client or his or her interests, okay?
Yes, Ron, I'd just like to add, I appreciate everything that you said. The one thing that I would like to stress, when you were talking about what you were talking about just now, it felt like you were blaming the defense.
I'm blaming everybody. I'm not blaming, like I said, I can't determine who's doing this. You wrote that in your motion, Madam. And I'm not casting aspersions. I'm not blaming you, and you did that in your reply to the state's motion. This is something that affects all of us. And until I find out, or if I ever find out who it is that did it, then I'll have that conversation with that person. But I'm reminding everybody, all sides, that this is something that is a joint responsibility to adhere to. 1.6 is the bedrock of what we believe and what we do as lawyers. We safeguard people's business and their secrets and their confidences, and we don't disclose them, even though it might be satiating and interesting and get other particular, be newsworthy. It's just not. And the reason that we signed this order, both sides asked me to sign this order, is because of the fact that we need to be able to safeguard information and individuals. That's why I did it. And that's why I'm kind of annoyed that the whole thing, that somebody just decided, hey, forget what the judge ordered. I'm going to just go ahead and release this. So, Madam, to your point, okay?
All right, thank you, Judge. And depending on the outcome of the investigation, I may renew my motion.
Yes, ma'am. It certainly would be within your purview, if in fact I get it, whenever I get that done. Yes, Mr. Matthews.
Can we ask that the court reflect in the order that this is a joint request by both the government and the defense? Because I think we're all interested in determining this, not just the government.
No, it's going to be my investigation. It's going to come from me.
Okay.
It's not going to come from any particular side. It's going to come from me because it's my order that somebody violated.
Thank you.
And also, it's not going to, I'm sorry. And also, are you also saying that you're denying the state's motion to restrict our obtaining of discovery at this point?
Yeah, but if I have one more disclosure, you're going to get restricted. Your restriction is going to be not their office, my office.
Understood.
Now, I'm presuming that will be after the investigation to determine how this got.
One thing at a time. I need to first sign the order, and then I need to kind of figure out where we go from there. That'll be something that I'll go ahead and let you know as it becomes appropriate. Okay? Yes, Mr. Jimenez.
Sweet time, you answer the Mr. Dorsey. Your Honor, on your rule now, so you say that we ask today is the time for us to let you know why their request shouldn't be granted. You're letting us know today that if there's another leak, wherever it comes from, we will be restricted.
I hadn't decided that yet, but that is one of the things that I potentially could do, because if I can't control who leaked it at that point in time, if there's another particular incident, I'm going to have to relook this particular issue.
Well, I find it necessary to bring up some issues as to the way discovery is being brought, and I also feel like I need to address this because it is under motion, specifically Section 2, where they seem to allude.
But you all have a duty as advocates to me, not me personally, you're a member, but to the profession and the bench to adhere to the rules. So it doesn't make a difference who raised it. The state raised it. You could have raised it. Ms. Bernard, did raise it. She was the first person to raise this under an issue of she just moved for mistrial. But so it doesn't make a difference who makes the motion.
No, that's not what I'm trying to say, Your Honor. What I'm trying to say is that in their motion, they are specifically complaining that this leak happened after the defense.
But I can't determine that. I'm not going to determine that today.
So I just want to.
Can you just wait till I do the investigation? And then that's why I didn't get into all of that was put in the motion. We're not going to. It doesn't behoove your clients for us to discuss all that right now. It affects their ability to get a fair trial and lawful trial. Just let me go ahead and do the investigation at this point, and then we can revisit this other who may be responsible at another time. It's just allegation and assertion at this point in time. So all you be doing is asserting some other position, and right now it's not the position's not important to the court. What's important to the court is a disclosure has occurred. It's been noted to me, and I'm not happy with it because somebody violated my order. That's the bottom line.
That's not what I'm trying to say, Your Honor. If I may just finish. What I'm trying to say is I think as a group we have all identified a possible flaw with the way discovery is being released. And if I can express it to the court, maybe we can address that to prevent any future disclosures, whether they are intentional or not.
Well, I hope they're not intentional, because intentional will get you in a lot of hot water with me.
I can assure you it's not me. It will not get me in hot water because I am not disclosing anything. There is no staff. You're looking at the secretary, the executive, the senior. Everything in my firm is done through me. And I can assure you there's been no leaks from the Chada Jimenez law firm. However, the state is providing discovery through an unsecured Dropbox link. Anybody with access to that link has access to the discovery. It's not even password protected, Your Honor. That is just the bare minimum for something that has a level of confidentiality to adhere by Rule 1.6. My discovery, as I requested and as they're complaining, is right here. This is my discovery. And I invite the state, look at it. You can't get into it without my fingerprint because I asked for it on a thumb drive, on a hard drive, so we don't have that issue. I am just saying, we are asking that if the state has any future discovery, give it to us in a secure form as a hard drive. That way, I have it in my possession, not as a Dropbox link.
Do you have I don't have an issue with that if you provide the state with the drives.
Of course, I provided them that,
Well,
but
that's a suggestion, certainly.
yeah, because I definitely do not want to be restricted. I think we need access to the discovery, especially I don't want to be restricted if somebody else, whether it was from the defense or the state or some rogue officer or somebody that in the internet feels very passionate about this case and wants to start digging, the Dropbox is not secure. We need to do a better way. This is not new. This is just, even a password being assigned to that Dropbox link would have been the bare minimum. And this is the state providing the discovery on. I just wanted to bring that to the court's attention. I'm not here to blame anybody. None of us benefit from the leaks of anything.
And I appreciate that suggestion. That is a good one. And I think I will incorporate that for future discovery exchanges. Okay.
Thank you, Your Honor.
All right. Anybody else? Any other defense attorneys, I should say? Madam, Ms. Love.
Thank you, Your Honor. And I appreciate Your Honor addressing the matter of having an investigation into this plea. Your Honor, I wanted to point out in response to Mr. Chada's suggestion to the court regarding providing discovery on a medium to counsel for the defendants. The issue, I believe, originally was that they were unable to download videos and the like. And for the entirety of a year, I guess, that they had been receiving discovery via that Dropbox link that they could not download from, this type of thing had not happened to this extent. It was only after the court instructed and we followed the court's directive to place videos on that type of medium that 20 days later or so, this leak occurred. Your Honor, we will of course abide by whatever instruction and directive that the court gives to the state. But we also have in mind a more secure method of transmitting discovery to the defendants, which will require any person who downloads or looks at that to have a password and a marker will be placed on that item that they look at. Now, we can't prevent unlawful cell phones from capturing those things as they are viewed. But, Your Honor, we'd ask that the court allow us to endeavor to provide future discovery in this method that will at least place a watermark on the pieces of evidence that we provide to the defense.
Well, I think placing a watermark on what you have is a separate issue, and that might not be a bad idea for it to occur, because then if it's transmitted, you know where at least that was what you got from the particular discovery that was in fact it's made of record. It's not a bootleg, but I do believe Mr. Child's suggestion of a drive being presented to you all, given to you so that it may be copied and they can, everyone has it can be protected by biometrics or password or whatever the nature. I just think we just need to kind of move to that at this point in time. So that's what I would ask that both of those two things be incorporated at this point in time from going forward. Okay.
And yes, Your Honor. And to be clear, the method that I was speaking of is evidence.com, which is the evidence holder for that the county uses that is secure, that we can send out discovery to the defense by way of.
Okay. Yes, Mr. Jimenez.
I just want to clarify. At no point I requested the hard drives. At no point.
No point. You what? I'm sorry.
Did I say I couldn't download it? I said it was too burdensome to download what it ended up being 2 terabytes. I had to download 1 file at a time. So I requested that they put in a hard drive.
I remember us having that conversation already about that issue. So
the state just said that we claimed we couldn't download it. And then after.
No. Look, let's not replow that road. I mean, I understand, and I certainly, the court concurs with you in terms of, I think Mr. Matthews also brought that up earlier about not being able to view that. If it's on a drive, it's a lot easier for you to move it around and take it and show your clients. So, I mean, that makes sense. And I certainly think that would be appropriate. The issue becomes, again, keeping the confidentiality of the data that you're given or entrusted. It's not to be shared with the people outside of, in this order. I mean, we're not trying to prohibit, the court is in no way trying to prohibit you from utilizing it to prepare and otherwise show to those parties that you necessarily have to, but it just can't go on social media wholesale like this particular interview did. So again, please don't do that. I really don't want to have an uncomfortable conversation with any one of you, but I will go ahead and have this ordered, have this investigated. And I'll keep you all posted on that particular issue as we go forward. Anybody else wish to be heard on that issue before I go ahead and move on to any other ministerial acts, and then we talk about hardships for the afternoon.
Your Honor, and I do want to be clear so that we can make certain to abide by all of the court's instructions. With respect to the dissemination of discovery from this point forward, the state, of course, will be utilizing evidence.com as it relates to the downloading of materials to terabyte drives and the like. What is the court's instruction to the state and to the defense? Are they to give us something?
Yes, they're to provide you the appropriate terabyte drives for you for that material that's subject to being disclosed for discovery to be put on those drives in working order, so it can be read or otherwise manipulated for their use.
Understood. Yes, Your Honor.
May I seek clarification?
What's your question, sir?
Are the existing Dropbox links going to remain open, or are we?
I recommend you terminate those. I recommend you move them to another space and place so that you can, or at least if it's not been password protected or otherwise enhanced in terms of security, that you do so.
Your Honor, and with respect to those links, each attorney has the ability to download from that link, and then.
Why do we keep going back to this download? The downloads have been a problem. The reason the downloads are a problem because of the size of the material you have. So I think that you're going to have to move away from that, Ms. Love. It's just too much. It's easier just to copy for their particular reason, since you've got videos and other things, to go ahead and just copy them onto a series of terabyte drives. Then they're portable. So I would just direct you to do that. Mr. Steele, do you have an inquiry or a comment? You're next, Mr. Matthews. Hold on. While you're what? I'm sorry.
While we're talking about this, and the state will tell me, but can you also put in your order, you consider when we will have all discovered? Can you put a date on it, or as a state? I keep getting discovery and it changes.
Well, of course, you have a continuing obligation to disclose discovery. I would just say that, the state needs to disclose that within, have you given all the discovery already, madam?
We have.
Or 95% of it?
That we have, and as we collect it, we send it out. We endeavor to have collected and identified all that is identifiable by the April 28th date that the court alluded to earlier. If the court instructs us otherwise, then we will continue to disclose discovery throughout, because we recognize our ongoing obligations.
The reason I ask is because the state of Georgia is giving us discovery last month that they had in October 2021. So it just seems like they have the discovery. I just want to know, it takes a lot out of us to get ready, and then it changes.
Sure. One of the things I might recommend you all do is just on a weekly basis that you or members of the defense, individually or collectively, talk with a representative from the state and make sure that you update your discovery. That might be the thing to do. I can order that to occur, that at least you have a conversation of, is there anything else that we need? And you pick a date during the week that you do that, or so that we can, so you can make sure that at least up to that point, you have everything you need. So I'll direct you to do that on a weekly basis, starting this week. You can pick whatever time you want. I'll leave that up to you all as professional advocates, and go ahead and take care of that. Mr. Matthews.
Yeah, sure, I agree with that. I just want to make sure that we have an opportunity to transfer our discovery to the proper USD, so forth and so on, before the government shuts down the boxes. We're going to take care of that.
They're not going to shut it down.
Okay, I want to make sure I hear the court.
I did say that they probably need to close that link, or at least, but if you have existing material, I would just say that you just need to, Ms. Love, if you do have something open, you have 10 days, okay? From today's date to go ahead and download anything that is not otherwise onto an appropriate drive. And if you're not able to do that to the state, you provide those drives to the state so that they can go ahead and facilitate that download, and you don't lose that information, okay? Yes, Mr. Jimenez.
And just, Sudi Chakimans on behalf of Mr. Dorsey. And to reiterate what the Honorable Brian Steele was saying, I think the issue that we're trying to get at is not ongoing discovery, newly discovered discovery, new postings, that's fair game. But I am requesting that there is a deadline for existing discovery, because it should have been 10 days before trial. And I get it that there's a lot, and I get it that there's a lot of agencies. However, for example, this video, I think it came back in the link 9 from the Dropbox that this video was in, and they've had it for years. It is not newly discovered. If it's in the possession of them or law enforcement, it's deemed to be in the possession of the state, and we should have had it 10 days before January 9th. That's all we're asking. New discovery, yes. If I got discovery to turn over that comes up since then, I'll get it to them in a timely fashion. But old discovery that already exists and is in their possession, we're asking for it to be turned over by a date certain, and if not, to be excluded.
Here's what I'm going to do. I'm going to direct, because we're going to be, I think, have some days that are down next week due to some unrelated business that the court has. I'm going to direct that you all meet on the 7th and 8th of March to have a discovery conference to see if you can resolve any and all discovery issues that may be outstanding. And then you can report back to the court. We'll pick up on the 9th, and we can report back. You can tell me what you think is missing. But I'm going to direct all counsel to that is the state's counsel and the defense counsel on the 7th and the 8th of March to meet. You can meet in my courtroom in 8F, and you all can have individual or collective conferences to make sure that you have everything you need. Okay?
And Your Honor, with respect to that date,
your clients will not be brought over for that date. It'll be attorneys. It'll be just to the purposes of discovery for that. Okay?
as there are things that we are requesting and have requested of certain entities, I would ask the courts to be allowed to inform defense counsel of those items and to commit to having them no later than April the 28th, because there are things that we are aware of that we are waiting.
I think you need to tell them that. I mean, in interest of full disclosure, I think that fosters just one, your responsibilities, and two, you're not playing ball, hide the ball with them. You're just telling them, hey, listen, we're expecting, to get a report from the GBI. It's been outstanding. They should have it to us by this date. You'll get it. So you all can track all of those, kind of outliers that, or even things that you've been promised by third parties. They can know that they, being the defense teams, can know, hey, well, we're tracking this and you're tracking that as well. But at least let's go ahead and get I think having that conference for you all would be beneficial to make sure that everything's been disclosed thus far and that we have a plan going forward, okay? All right. Anybody else, anything else? All right, councils. Any other, we're going to switch subjects at this point in time. Any other ministerial inquiry with me before I go ahead and talk to Mr. Randolph and Ms. Von Kelsch for our next group of jurors? Okay, all right. Ms. Von Kelsch and Mr. Randolph, Madam, Sir, Ms. Von Kelsch, if you want to go ahead, and do you have any announcements that you wish to make? And can you tell us from this morning's examination what the preliminary pool looks like to be examined for hardship? Yes, come on up, madam. You can come up to the podium. I think everybody will be able to hear you at that point.
Okay. All right, so we had jurors 614 through 714 report this morning and complete their questionnaires. We have approximately 50 to 60% who have identified hardships.
And that's from either them self-identifying or from the questionnaire themselves, correct?
That's right, Your Honor.
Okay, all right.
So we retained the first, we retained 614 through 650 to present hardships today. That totals 30 hardships to present today, and we released the remainder to come back on another day.
Okay. All right. So councils, we will try and get through as many as we can today. And if we'll do the best we can, and then we'll push them to another day. And we'll, like I said, we'll just continue like we did last time. I think we'll go a little bit faster this time since we've asked people for juror policies and other information that will expedite us having to bring them back multiple times. Okay, madam, any other announcements?
Yes, Your Honor. So juror 616.
Okay, juror 616.
We
Yes.
have him listed as no hardship, but there is a travel hardship. And juror 623 is a language.
Hold on a second, y'all. 1 second, 1 second, 1 second. She said Sylvia fell asleep. I'm up. Trying to find something. Okay, let's see. Okay, 1 second, y'all. One second. I'm trying to pull this up. Just a second.
I have another unrelated business and I haven't heard it. Is Miss Bonkel's back? I don't think she's back quite yet. I think she's still in the process of dealing with our jurors that have come in. So I'm going to take up another unrelated matter to you all in about 10 minutes. And I should be back and we can recommence at 11:30. And I can take up, we can then get an idea of how many people we've identified for the first day here, and then have a plan for for either the remainder of the morning or early afternoon for us to examine those particular individuals. So, any ministerial inquiry with me at this point in time?
No, I'm sorry.
Yes, Ms. Bernard.
On behalf of Jada Myrick, there was a motion at the state to file, and I saw a Rule 9 sign for today.
Yeah, I can't take it up in 10 minutes.
I got that, but I wasn't sure if we were gonna do that today or something.
Which motion is that one, madam? I think it's I'm sorry?
Discovery.
Yeah, I'll tell you what, let me just kind of see where things go with our schedule today. And I may be able to take up that at this point in time, shortly. But I've read the motion and the response, and I think I may have some ruling or thoughts from the court, okay?
And may I also inquire about the other motion that I have filed, and then what I also filed is.
I'm not hearing any motions for mistrial, not hearing anything else at this point in time. Okay, all right, I mean, in terms of, I think the mistrial motion is related to what you said, so I'll handle that in tandem with that. That one I will deal with, but anything else, not at this point in time.
Thank you.
Okay, all right. Okay, so give me, like I said, you all can be in recess until 11:30. We'll come back down. I'll check on Ms. Von Kelch at that point in time, and we'll continue forward, okay? Anybody else? All right, we're in recess.
All right. Okay. All right, let me see. Whoever got Sylvia's numbers. Call me. Why? Why do I need to? You need to call me. Sharon, what you need to call me for? No, I had woken up already, and I changed the video. Why she keep calling me? Tell her stop calling me. The phone is in the other room. There's no need to call me, guys. Oh my gosh, tell her stop calling me. Why is she calling me? Tell her the phone is in the other room. It's showing on my computer. She can stop calling me. Yeah, y'all started sending me messages at about 2 something. I was at 2:33. Y'all started calling me. Yeah, there's court tomorrow. It starts at 10 o'clock tomorrow. Oh my God, stop calling me. Why are they calling me? I am up. God, somebody please tell them I'm up. Can they not hear me? Sharon, I am up. She has to be behind. She keeps calling me. And my phone is in the other room where my husband is. Remember, I have a household of people here. I have a household of people. She asking who's sleeping. Okay, let me see. Let's see. There's a bug on here. Oh. Hey, Sammy. All right, let me see. I'll see what I was going to put in. Let's see what I was going to put in here. Hold on a second. trying to see. Okay, we can't find anything on that one. All right, there's nothing on that one. Let's see the next one. There's nothing on that one either. Let's see the next one. All right, hold on a second. I got something. I got another footage. Yeah, I couldn't sleep, y'all. I was in the other room. My husband's not knocked out snoring, and I couldn't sleep. Let me get in here. All right, let's play this one here.
Okay. Cool.
All right, here we go. Yeah, Sammy, I've been up late,
Okay, but
pretty late
we're gonna do
before.
the best we can, right?
Oh, you got 10 minutes, Rob? Okay. All right, my leg is hurt. Hey, Ugly Money. How are you? Up mighty late? Sharon, you must be delayed. Your phone must be delayed. Your computer.
Bless you. All right, Deputy Talton, are all our participants present? Okay, all right. Council, any of your colleagues are not with us, otherwise haven't been accounted for? Okay, all right. Mr. Randolph,
Yes, Your Honor.
is Ms. Couchel with you as well?
Yes.
Okay. Oh, wonderful. Okay, all right. Go ahead and you can invite the lawyers up to pass out the jury information and otherwise lists for this particular panel.
Young Thriller, I'm about to end it because we almost finished. I've been on for an hour and 30 minutes now.
All right, councils, if you or a representative would come on up in an orderly fashion to visit with Mr. Randolph, he'll give you the paperwork for this particular panel starting at 6:14 and going through 9:05.
Hey, Nate. Is this going to be posted? Oh, yeah, I'm going to post it. This is posted. This is from earlier today, well, yesterday, because this is a new day now. I know I heard you the first time when you said you was up already called you back in, so I don't know if it's a delay or not. I think it's a delay. What they're going to do is going to get the list of the jurors. So they're getting the list. The new jurors from 6:14, well 6:15 all the way up to 914. Tomorrow he's not going to get in until 10 o'clock, which means about 11. This trial is not going to start till about like June, mid-June. That's when you'll hear opening argument.
Well, no. This is on the first. There's 27. This is on the first. That's the first. Yeah. Okay. There's Curtis. There's an affidavit, 6:35. So, yeah, 6:35. 6:35.
I'm trying to see. They said there's another motion filed, so I'm gonna check to see what motion was filed. All right, guys. That's it on this one. That is it on that one. Let's see something. Hold on a second. I was trying to see if they had any other motions. Trying to see if there's any other motion that was filed. But anyway, guys, I am about to hit the sack. I'm going to have to hit the sack now. Let's see. I thought I had something else in here, but I don't. Well, anyway, my lovely people, Thriller, young Thriller, you can go back to the video and you can see some of the motion that was filed earlier regarding to the two ladies. They postponed it until the 24th of April, so they have not been taken off. They have not been taken off because remember they were trying to separate them because they were pregnant. So they haven't done that yet. Okay. Anybody have any questions? Because I'm about to get off this live and go on about my business. Any questions? No question? All right, good people. It is 3 a.m. I'm going to take my butt to bed because I'll be getting up in a few. All right. I'll see you guys later. Night, night. Where my thing at? Yeah. My brand. I think to take me on out. It's not showing. Oh Lord, where is it at?